all the red line revisions that we have made since it was out for public comment. So for those of us that are continuing members, a lot of these revisions have already been discussed, and we've like agreed to those and had conversations about them. And so what I'm going to do right now is to highlight the changes we made from our last discussion into today. But we thought, kind of debated what would be the most useful for people. We thought that especially for the new members, to see all the public comments, which we've already discussed, and how we've incorporated them into this red line draft would be most useful for those new members. And for the continuing members, a lot of the issues that we talked through, we've already talked through and made revisions on. And so I'm going to highlight for you the changes we made based on our conversations at the last meeting. So the one change that we made is that you can see it in the digest at maybe lines 11 and 12, where you see we made sure that we had consistency throughout the opinion, that we're not saying that the use of the provision is necessarily problematic for that attorney, but it's the promulgation and enforcement of it. So we kind of go through this analysis and describe the ways in which, you know, under the different hypotheticals, what the attorney's obligations would be, but we wanted consistency around that and clarification around that would be sort of an additional step instead of just saying, hey, the third party is going to use it in the contract and we may or may not have control over that. But when the attorney is actively in a position where they're trying to use it to negotiate terms or trying to enforce it, that would be a different ethical implication. So we've had consistency there. And some of the other changes that we made go to the fact scenario. This is just changes that we've made. If you can go down, I was going to say Mimi, but it's not Mimi, it's Andrew. To the fact scenario, I think maybe it's lines 61 and 62. Up to pages, the first facts. Yes, facts 1 and 2. So here, we wanted to make some sort of beef up the fact section, just make it clear when we're talking about knows that it's illegal, but the attorney's in the first scenario advising HR to use it anyway and doesn't give advice or analysis, just making that clear that the attorney's not saying, you know, I know it's illegal. I'm describing to the client about that. They're just saying, yeah, go ahead and use it, right? So, and then in the second scenario, because we think the second scenario implicates duties, competent attorney duty, we wanted to make sure that we included facts to sort of more fully demonstrate the fact that, you know, the lawyer doesn't know, but it's not just that you don't know some sort of arcane issue, that you basically don't know and made no effort to determine whether or not the provisions were proper, but, you know, told them to go ahead and use it, didn't give any advice or analysis. So we were trying to really sort of beef up that part of the scenario number 2, which relates to our comments further down in that particular section, Andrew. And for the people also that have been on the committee for a while, there's revisions, as you can see, making it clear. There was a lot of feedback about what we meant when we were talking about illegal. And so a lot of the revisions that we already made were an effort to make very clear that we're talking about a provision that's illegal under the laws of the jurisdiction applicable to the transaction. It's not intended to be something that's like, there's a question about whether it's an enforceable or you can make a good faith argument. We're talking about something that's clearly illegal. So we made a lot of language changes around that. The other change we made is I'm sorry, Andrew, because I'm looking at a slightly different version to focus myself. It's the section right at the end of section A, like however in scenario 2. Yeah, so some of the changes that we made there, again, relate to how we describe it in the fact section, but we wanted to make sure that we are talking about, you know, the violation of the duty of competence, because there was sort of a reckless disregard for the lawfulness of the provision, that the attorney didn't even bother to look at that. We discussed how it's reasonably likely to be necessary for, you know, as a provision of an HR contract for the attorney to know about that. And so we, you know, beefed up the facts around that so that when we were talking about whether it could potentially be considered gross negligence or reckless and grossly negligent under rule 1.1a, that we really have the facts to support that conclusion. So that was an effort to to make that more clear, and not to suggest that just because in one circumstance someone didn't know an area of law that would give rise to a violation of the duty of confidence. So that was we felt like facts would better able to support the point we were trying to make there, which is what we wanted to raise in this circumstance. And then I think the other change that we made that was more significant was related to section C, Andrew. I think it's like a 191 line, or at least on the version I'm looking at, which is just shows the changes. And this was about feedback we got about the duty to withdraw from the representation. And we wanted to, there were some questions about, and we left it open in our hypothetical about whether that attorney who is advising HR on this provision or has been asked to look at it was actually an in-house attorney, or whether they were an attorney from a law firm that was advising. So and that there was questions around that, and we wanted to in our footnote 12, Andrew, we added some more language to sort of say in the case of an in-house lawyer, that we sort of revised some of the language around there. We were talking through footnote 12 at our last meeting. I don't think no, that's not that footnote, Andrew. It's been renumbered now, or I'm calling it the wrong number. Yeah, sorry, 16 is the one that I'm talking about here. That footnote where we basically say in the case of an in-house lawyer, we assume that they would be permitted to limit the scope or decline the representation if it was, something more to negotiate or advocate or litigate if that wasn't in their normal scope of their duties. And we wanted to make clear that we were not going to opine on whether or not, they were required to terminate the representation from the company, because that would be very fact specific and would be depend on a lot of different things that we didn't want to opine on in this opinion. And I think that's it with respect to the revisions we made based on our last meeting. Obviously, substantively, when you look at the red line, you can see that there were a lot of revisions and clarifications of language to tighten up some of the analysis based on feedback that we got from a variety of, bar associations and legal ethics groups. So I think the other comment I want to make before opening up for a public comment is what we're at least from the committee members that were present, continuous members. Our view is that these are the revisions that we made with the idea that we would be in a position to vote it out for another day, a round of public comment, potentially a 60-day, which is typically the second round of public comments that happens. And so that's what the goal, I think, is for this. And I don't know if either people who are continuing members want to comment on the changes that we just made, or if other members who are new have other questions about changes that were made to the opinion.
Well, and before we open up there, I just want to note for the new members that we included in the agenda materials the public comments that were received from the first round of 90-day public comments, so that you could see what those comments look like. And then now you have the red line, which includes our reaction, our responses and changes, including to address concerns that we thought might have been valid or appropriate to address from the public comment materials that you have in your agenda materials. Thank you, Dina. So I have a few thoughts and comments on this, but I'd like to open it up to other folks first, if anyone would like to comment on these very helpful revisions that have been made since our last meeting. Okay, well, why don't I go first then? Can you hear me all right?
Yeah.
Okay, great. So I really appreciate the efforts to make the language consistent and parallel throughout the whole use of promulgating or enforcing throughout. It just really adds a nice organization and consistency that I think I'd like in our opinions. And so thank you for that. In terms of the new language and the factual scenarios, I would propose that we do a little bit more wordsmithing here. I thought that the addition in factual scenario 1, at the clause at the end, without further advice for analysis, I think we could be more specific, because I think what we're trying to say here is that the lawyer knows the provision is illegal under California law and advises HR to use the agreement anyway, not informing HR that the lawyer knows it's illegal. I think that's what we're saying when we say without further advice or analysis. And I think we want to make that more explicit, that if that's what we mean, that this lawyer knows and he just tells them, yeah, go ahead and use it without informing them of its illegality. Does that make sense? Or are we trying to convey something different?
No, I think it's fine. I think the effort was to make to parallel the language below, which was, you know, from prior drafting. And when I just read the lawyer knows the provision to be illegal, I found that it just didn't, when I was going back to, I was in the lead drafters, I was going back to revise it. I was like, what do we mean when we're saying that? So I was trying to add more language, and I was trying to make these sort of parallel to each other. I kind of, had some issues with sort of same facts, and I'm like, which same facts are we talking about? The ones above, or are we now incorporating
Right.
one? And so I was trying to balance that. I always struggled with that part of this, so I'm open to making it sound, say what we really mean it to say, which I'm fine with the way you've revised that.
I feel like we should just do some tweaking to say what we mean, because now even with these, the same facts, that phrase doesn't work even if we didn't make my change, right? Because factual scenario 1 says lawyer knows it's illegal, but factual scenario is the lawyer doesn't know it's illegal. So it's not the same facts. And yes, we have the—
But it's the same facts as in the fact pattern, which is what you're saying, right? It's the same facts, it's in the big fact pattern. And that's always, yeah, right?
Yeah, it's kind of ambiguous. I mean, I don't even know that we need to say same facts at all. Since the statement of facts applies to each of the factual scenarios, I don't know that really adds much.
Yeah, I'm not going to defend it. Yeah.
Yeah, no, I hear you. I just felt like the without further advice or analysis clause, that's what really I found ambiguous, that I think we need to clean up a little bit. And then, with going to factual scenario 2, I think we might be able to just say lawyer does not know that the provision is illegal. I don't know that we need the same facts. It's implied in all 4 of these. But now that we've added that the lawyers perform no research, again, that last clause, without further advice or analysis, is somewhat duplicative and vague at the same time. But I think that's what we mean with, I guess, analysis. The lawyer hasn't done any research to determine its legality. And so I think the way you've revised this is more clear. It's more specific as to what we mean by analysis. And so again, I think
we could say no research or analysis, but yeah, I think you could end it after anyway. Yeah, but
yeah, let's if we could do that, that would be great. So performs no research or analysis to determine the legality. And then we don't need that last clause, which is I just feel it's very vague.
Just please confirm if these edits are what you're requesting.
Yeah, I wonder if we should just make it consistent though, and not have the without further advice or analysis, which I agree, Justin, is ambiguous what we mean, but why don't we also include, maybe it's already in here, but without informing HR of the illegality at the end, replacing without further advice or analysis.
But they don't know it's illegal in that one, so they can't advise of it.
I'm sorry, this is the one they don't know. Never mind. I apologize. Yeah, that makes sense.
And then again, with 3 and 4, I guess we could just remove the same facts except that phrases and just say lawyer this, lawyer that. And it's implied through all 4 of these that the fact pattern applies to all 4. But if someone's seeing a problem with doing that, call it out and we'll tweak it. So had a couple more comments, largely around the paragraph that begins at line 99. Yeah, now line 100. So we say at what is now match up my lines here. Oh. What's now line 101, because lawyers' conduct reflects a deliberate or reckless disregard. But then going down to line 111 now, we talk about might be reckless or grossly negligent in relation to this conduct. It seemed to me those were talking about the same or similar concepts, and so I was wondering if we should have a might or a may before the word reflects on line 101 to be parallel to what we say in line 111.
Well, I think line 111 is generically talking about a lawyer who fails to consult with another lawyer or acquire learning that lawyer under those circumstances might be reckless. So that's a generic saying. Here we're talking about in the factual scenario at the between 109 and 111 that they likely violated the duty because their conduct reflects that. I'm not sure they're exactly parallel in that way, but
no, that's fair. That's fair. So then that begs the question: is are we comfortable with that conclusion that the lawyer has engaged in conduct that reflects a deliberate or reckless disregard for the lawfulness of the provision? Because I guess in scenario 2, the lawyer didn't perform any research and didn't know that it was illegal under California. That provision was illegal under California law. Is it a deliberate and reckless disregard because the lawyer failed to perform any research in providing advice to the client? Or is it possibly a deliberate or reckless disregard? I've raised the question because, this is obviously an absolute statement. So if we feel confident that that's absolutely a violation, failure to do any research and then give the advice, okay, fine. But if we don't mean to say that, then we would need some kind of clarifying word like might or may.
well, that's why I think we have likely in the first sentence. We're not saying it's absolutely violated the duty, and we could add more language. I mean, this is based on the conversations we had at the last meeting. I mean, I think we could add more qualifying language if we wanted to the second part of that. I mean, the goal, whether it was to try to create a situation, it's not just that the person failed to do research, but they told the client that it was lawful and they didn't know whether or not it was, and they did no research. I mean, on these particular types of provisions, if you're doing employment law, and saying to the client that this is all permissible without even looking into it, then, that's potentially reflecting sort of, reckless, deliberate disregard for the lawfulness of the provision. They didn't ask for help. They didn't do research. They didn't say, so that's the situation we're trying to suggest. Not that anytime you don't do research on a provision that you're violating your duty of confidence, right? But to say to a client that it is lawful when it's not, and you don't, and your basis for knowing it is just because you didn't actually do any research or consider whether it was, that's sort of what we are trying to say would maybe rise to the level of, this higher standard that could trigger that, right? I mean, so that was, I think, what we were trying to implicate here.
No, I'm totally with you. Here's where I'm a little stuck, is I don't feel that the use of the word likely on 100 sufficiently modifies the reflects of deliberate or reckless disregard because of the because clause. And so if we mean likely to really be saying might reflects as opposed to definitely reflects, I would feel more comfortable sticking in a might or a may before reflects. And the other part of this that got me stuck is whenever I think of the 1.1, I think of standard of care issues. And I'm always a little nervous, making, even though I see the problem here, I always am nervous to make statements that could be construed by someone down the road as opining on a standard of care issue in a way that might be used in a way that we don't mean, because we're focused on ethics rules. So,
I totally hear you with that. I think that,
go ahead.
No, I think it's fine to modify it that way. I mean, I think the challenge with this was that we were trying to have a conversation around the duty of competence with this, like to say, if we could have taken the position that it was sort of a benign oversight that was like didn't rise to the level of a 1.1 violation, but then we're basically saying like, it's okay to tell your client like, oh, this is fine when you haven't done any research or considered it, and it is in fact not fine. So we don't want to say that, right? So that it's trying to sort of create the situation where this kind of conduct could give rise to this. I don't think we want to say absolutely under this factual scenario because there's only like 2 sentences in the factual scenario, right? But so I'm fine with the modifying language there. I think that this is something that Sarah and I discussed based on the feedback, and it was like trying to, if we're going to say it could be grossly negligent, then we need to really sort of like make it more than just an ordinary, oh, I forgot, I see this provision, didn't do research. I mean, if we're, talking about non-competes, but not talking about non-competes, if you're in employment law, you know about what a non-compete is, right? And if you don't, you shouldn't be practicing employment law, right? So that to me would be, I mean, again, standard of care, we're not opining on that, but it's sort of like this very obvious extreme thing where it's the main one, a very important issue to the type of work you do. And you're like, oh, I've never heard of it, and I'm not gonna, look into it. That would be the situation we're trying to sort of portray, but modifying language is fine there. Whatever people are comfortable with, I think is what we should do and think is best reflects what we want to say as a committee.
Right.
This is Brandon.
Go ahead.
Sorry, I was just going to agree with Justin's point, and I don't know if this is the time to bring it up, but the lack of a comment letter kind of freaked me out. The fundamental concerns that they're expressing made me wonder if we are on the wrong track or not properly conveying what it is we're trying to convey in the opinion, because they seem to, it's almost like a sky is falling letter, comment letter that I just wanted to talk about here at some point, because it was unlike the other comment letters we'd received. They seem to think we are fundamentally on the wrong track and creating a minefield that should not exist, or acting as if one does exist.
Well, Brandon, we've talked about it since the last couple of meetings, right? I mean, don't you think we've addressed a lot of these things? I mean, the ambiguity was one of their problems and stuff with that. I mean, I think we've, this is like the 3rd time or 4th time we've discussed it. I think a lot of this has addressed those concerns about it, right? I mean,
it may have. I guess it had quite an effect on
if we look at it, right?
Yeah.
It's like completely different in some ways than the opinion we were asked to do, right? So,
right.
Yeah.
So, unless anyone has some
Justin?
strong, go ahead.
Yeah, I think it diminishes what you're trying to say if you overly modify it. I really do. I mean, I think it's quite clear from my standpoint what Dina and Sarah were trying to get at in the way that this was written, and the likely violated provides you sort of the balance that you need. But I think you start to lose it if you overly modify it and hedge. That's my non-lawyer opinion.
I fully appreciate that. And what I'm suggesting is that I was only an English minor. My grammar is not the best, but when I see a because clause, what comes before it when you have a modifying term like likely doesn't necessarily apply, or it can be interpreted as not applying. And so what this sentence as written, in my view, can be interpreted as saying is that the lawyer in scenario 2 engaged in conduct that amounts to a deliberate or reckless disregard for the lawfulness of the subject provision. And I'm not saying I don't agree with that, okay? Let me be real clear. This is the type of fact pattern that lawyers in my profession prefer not to see come around on their desk, right? The lawyer who doesn't do any research and then gives the wrong advice. I mean, not a good fact pattern at all. But the question is do we want in this opinion to say that statement as absolutely, or do we want to avoid potential criticism that we're reaching that conclusion when we don't have to, or given that the fact pattern in this opinion is pretty circumscribed, that it could then be construed in more nuanced environments in a way that we don't intend. That's really my concern, kind of big picture. Not that I don't agree necessarily that this was a deliberate or reckless disregard personally, but I'm more thinking long-term, big picture is, do we benefit from putting the modification there? My personal view is that we do, but if the consensus is different, that's fine. But I would feel remiss if I didn't raise the concern.
Yeah, Justin, I understand that concerns you're raising, and one thing that I guess has developed a little bit more later in this paragraph is just, I don't think in every situation, it depends on what type of clause it is in the contract. It might be a minor provision, and that wouldn't necessarily reflect incompetent conduct on behalf of the attorney. But I think we modified it slightly when we talk about it being a material provision here. I forget what line that's on, but I do think the facts we have here, where the lawyer conducts no research and doesn't consult with anyone, and I don't know if we need to clarify too that it's a material provision, and it's well established, and that it's, you already, I think, clarified that it's well established that this provision is illegal. So under these facts, I feel comfortable with using likely, but I'm not clear, how would you modify this line 100?
I would, two options. I would say one is to just end it at likely violated the duty of confidence under Rule 1.1, period, or I would add a might or a may before the word reflects on line 101.
Well, it does say that on line 111.
Yes, I raised that point earlier.
Right.
And I was saying, well, okay, for a parallel reason, why don't we say the same thing above? But Dina made a good point, which is that at line 111, it's more describing the general rule rather than as to the specific application to our facts, which is what it comes above. All right, well, maybe
while we're on that point, Justin, sorry to interrupt. I just, as I'm looking at, if we're trying to be more general, I'm wondering on line 111, if we should just change it to a material legal provision as opposed to limiting it to employment law. If that's intended, if we're intending that to be more general at Dina and others, but what do you think if we?
That makes sense, yeah.
Absolutely.
I mean, we could put in that fact section above, like at the very beginning of the facts, we could add, like you said, Sarah, the word material. Like Andrew, if you go up to the statement of facts, if we could and say which contains a material provision, right, on line 52, if you wanted to make sure that it's not just some,
That definitely helps, and I think even if I didn't have this concern, I think that's a great addition. Well, maybe we can just ruminate on that point for a little bit more, and then I can just move on to a couple other comments on what appears as footnote 8, where it says the committee would reach the same conclusion. Yeah. I have my idiosyncrasies. As some people on the committee already know, I am a fan of our shorter opinions to bring back to something that Brandon said earlier, and I think that's something for us to work on. Another thought I have is to avoid Latin wherever we can, because I thought I understood what that meant, and I guessed right, but I had to Google it, and I don't want our readers to have to Google Latin. So can we just say the committee would reach the same conclusion in all 4 scenarios if lawyer drafted the subject provision originally, or was alternatively advising on the provision as drafted by another, something along those lines?
We also have a strict style rule at CEB to not use Latin. And what we use for that is we just say if lawyer was the original drafter, or if lawyer or lawyer's firm was the original drafter, I think is a commonly used phrase.
That sounds good, Kyla.
Yeah, this is some of our, for David Carr and others who like to use a lot of Latin. Yeah.
They can't complain. So yeah.
Well, right. I mean, there's things in here, yeah, right. Like some of those things where it's like, yeah.
All right.
So before we leave, I just want to confirm this edit captures everyone's thoughts and concern.
Yeah, I would say either the original drafter of the provision or of the agreement. I wouldn't just leave it at drafter, but.
Anyone have a strong view of for provision instead of agreement here? The original language was agreement.
Well, the fact pattern says that they're tasked with reviewing and updating the agreement. So that's what we wanted to convey, was the idea that if they were the original drafter, which is what this says, and then that's what the language turned out to be. Yeah. So
Cool.
this is that. Yeah.
Just one other comment was footnote 18. What is shown as footnote 18? And actually, sorry, if we could just go above to the text where footnote 18 is, since we're probably going to vote this out for public comment, can you delete the article right before HR's conduct, the right before HR's conduct? And then as for the footnote, what my question is, either do we need it or do we want it there at the end? Because it looks to me, I can't, just looking at the red line, I'm wondering if this was a legacy from when we hadn't put in one place in footnote 1 or 2 that explanation of what we mean by illegal, or if this actually ties to the duty to report up in an organization, is meant to tie to that subject.
Can you go to what the footnote
presently located?
Yeah, that's what I was looking for, the body, what we're seeing in the body.
Sorry, I'm trying to find it.
Because it's citing the labor code about
in the body there, that's where right above conclusion, there's a
okay.
reference to a footnote 19, but we don't have a 19.
Hang on, I'm just trying to put this all on one page. So 18 is right here, following the term illegal.
it looks to me like this footnote 18 about citing the labor code is kind of a vestige and doesn't relate to the duty to report up. But if I'm misunderstanding, let me know. And then I have a proposal if I'm right, and if I'm wrong, I'll just be quiet.
I think it's fine to remove the reference to the labor code provision. It seems like it was cut from the body here somehow and put in the footnote, but I don't think it's necessary, and it's really a legal issue, so we probably shouldn't have it in the ethics opinion, especially since we're just assuming the provision is illegal.
Yes.
Well, I think
That was-
it's trying
go
to
ahead.
demonstrate a situation that would give rise to when the person would have to report up, because they're knowing that this is illegal and it's prohibited, and so they have to report it up, right? I'm not sure that it fits as a footnote to that particular sentence. And I don't know. I mean, I don't know if we should delete it entirely, because I think it's valuable, but I'm not sure it's a footnote to that sentence. And it certainly doesn't relate to the duty to report. It relates to the situations if you drew a conclusion related to that you would then have a duty to report, right?
Right. I mean, it seems to provide, the labor code provision seems to provide context for our conclusion that the unstated illegal provision in an employment agreement is prohibited by law and therefore illegal, which is the assumption we make here. And so my thought was this might be more appropriate either as a footnote in the statement of facts or as a sort of C labor code reference in the footnote 2, where we actually talk about our use of the term illegal.
I think that's a good suggestion. I kind of am in favor of keeping it in. I agree with you that it doesn't maybe squarely go in that spot, but I'd be interested what others think. I do think it was somewhere else before, Justin. I agree with you. I mean, this has been through different iterations, right?
Yeah, I mean, when I read it there at the end, I was like, well, wait a minute. This would be something that might be relevant to understanding the statement of facts and why we're talking about any illegal provision, or our discussion of, well, what is illegal for purposes of this opinion. And so, again, I think that this would be better suited as a footnote somewhere in that statement of facts section, so line 47 to 53, or as just a cite, part of our footnote where we talk about our use of an illegal term, which is footnote 2, also around the same area.
Yeah, I was just wondering though if it was meant to be, and I don't recall exactly when we put this in here, but I was wondering if this was supposed to be just to show that it's likely to result in substantial injury to the corporation under Rule 1.13, and that's why it's in this section, or it was in this section.
Well, here's the stricken language, violation of law reasonably imputable to the organization. I think that's where the footnote originally fell.
Yeah, that makes sense what you're saying, Sarah. I always felt like it needed a little bit more than a C also, but yeah.
But
Well, if we were to leave it there as footnote 18, I think we just need to connect the citation to the duty to report. So I guess that's the alternative. If there's a feeling that this citation helps the discussion of duty to report, I think we need to make the connection more explicitly for the reader. I don't have a suggestion how to do that. That would be my thought there.
Well, what do other people think about that footnote, and whether or not we should move it up in the opinion or provide more explanation, or if there's an opinion that it doesn't belong? I think you're right, Sarah, which is like, that's why it was in there, was like that question about harm, because if they're in the imputability thing, yeah.
Yeah, and for that reason, I'm in favor, if we're going to keep it in this section and not, I don't think it's necessary to add further clarification in terms of that the provision itself is illegal. I think we've made that pretty crystal clear with the other edits we made. So I think if it stays, it would stay in this section. And I do agree with what Justin said too, that it's not really clear the way it's with just the C also. So we could work on alternative language, or we could take it out altogether.
So I don't have strong feelings as to where it is, as long as wherever it is, it has a purpose, and the purpose is clear. And I think that removing the C also, removing the for purposes of this opinion clause, we're going to keep it in the duty report, and then tying it to this particular section somehow would suffice. But as written, it just kind of comes out of
what
nowhere.
if we moved it to the end of that sentence? This is just an idea to move it. There's so many red lines I can't even see. To move it to the end of it's substantially likely injury to the organization, and then we basically say in the footnote before it something like, a provision that is an unlawful provision. I can't really articulate. A provision that's substantially unlikely to injure. The use of an unlawful provision is substantially likely to injure the organization, and then see that, or whatever those comments are, so to tie it in that way, right? I'm not articulating how that sentence would work, but that, you know what I'm saying. Because it is supposed to be, and it got moved. It really is related to that second part of the clause, which says is likely to result in substantial injury in an organization. So the use of an illegal provision by a company is likely to result in substantial injury to the organization, and then cite to that or something. That's the way to tie it in.
I think that's right.
Did you want to add language too, or just moving the footnote is sufficient?
And I think the footnote should come after C rule 1.13B.
And I think we do want to revise the footnote, because like the last sentence in the footnote isn't necessary anymore.
That's right.
Yeah, I agree.
So just drop this sentence.
Yes. And then were we going to add a clarifying sentence before the C also? Dina, you suggested some language, and I can't recall exactly what you said.
Yeah, I don't know. A company's use of an illegal provision is likely to result in substantial injury to the organization, or may result in substantial injury to the organization. I mean, I guess the test is likely. And then we can say C also, I guess, to that.
Yeah.
That works, yeah.
Do you want may or is likely to?
I think we should do likely to tie to the rule. Is that, I think the rule uses the term. Yeah.
Because we do conclude that the reporting up would likely be in the best interest of lawful interest of the company. So I guess to conclude that, we'd have to say it was likely to result in substantial injury. I mean, I think that's correct. If they're using illegal provisions, that's, yeah.
All right. I have one more comment, and then I'll be quiet. If that's okay. Go back to that line 99 paragraph. Now line 100. Again, this is just more of a style preference. If you don't like this proposal, that's fine. I'm prepared to move on. But in the paragraph that starts a lawyer's I guess line 109, a lawyer's failure to consult with a lawyer who the lawyer reasonably believes, blah, blah, blah. See that?
Yes,
Yeah.
I do.
So it's tracking the same language as preceding sentence that describes Rule 1.1C. Got the same two clauses about. Yeah. So what I was thinking in the sentence I just read that starts at 109, we could just say lawyer's failure to do so might be reckless or grossly negligent under Rule 1.1A, and then cut out the duplicative phrasing from the preceding sentence.
I like
like
that.
that.
No, I do like it. I'm just wondering, Sarah had added some language about research related to material provisions, or I don't know how that I wanted to try to capture that, but the other part, I like what you're saying in terms of condensing it.
I think it works to take it out, but not take it out all the way to might be reckless. Keep the clause before that. So a lawyer's failure to do so, comma, or to acquire such learning and skill, right?
Well, I don't think that works because it's a two
Oh, I see. I
Prong.
see. Yeah, you're right.
I have
aspect of the
another,
rule.
Or acquiring sufficient learning and skill. Yeah.
yeah, what if we move at the sentence before, we're saying, sorry, I'm having trouble seeing on my screen, to become competent before performance is necessary. What if we say something like to become competent before advising the client on a material legal provision? Would that work, or?
Yeah.
Yeah, and then yeah.
Sorry, material.
Legal provision.
Yeah, so that's more specific to our what we're addressing in the opinion, and then we could just say in the next sentence, a lawyer's failure to do so might be reckless or grossly negligent under Rule 1.1A. Then we don't have to say the two-pronged aspect twice.
Yeah, I like that.
Okay, that's enough for me. Thank you for indulging me.
Thanks for helping make it better.
I've got one small thing, not to be the Latin police, but after we did the ab initio thing, Andrew was scrolling and I saw some more Latin. So
I'm all in favor of taking out the Latin. Well, that's the
in
effect,
line,
but yeah.
It was 127. We've got an in terrarum, which I think means chilling.
Yeah.
And when I searched in the materials, multiple of the criticizing letters quote in terrarum. Like one of them said, I think you mean chilling. So I think people don't like it. So.
Good point.
Very good. Any other comments?
So I think the only issue, well, not if there's nothing other comments, is about whether do we come to a conclusion about if we are going to qualify 1.1? Did we want to wait for further feedback from bar associations on that? What did people? I know there were some people that expressed yes and some expressed no.
I had made one comment earlier, just, I don't know if it's still there, but right above the conclusion, it was at line 213.
What's the comment?
Oh, now there was at the end of that paragraph, it was a footnote 19. Now it's changed to 20, but there wasn't a footnote 19. Great. Right.
Yeah, you're right. It's a ghost.
Sometimes it does that. I think it'll fix it in the final. Don't you
Yeah,
think?
we accept these. Yeah.
Does anyone else have comments regarding this draft? I'm wondering if we don't have other comments, maybe we should just look again quickly at the one outstanding issue Dina mentioned about competency and see what we want to do with that one sentence.
Is it this one?
Yes, that's line 100.
Yeah.
And I think the question just goes to whether we think, because I mean, from a construction perspective, I understand how you're deconstructing the sentence. I think we are saying that the lawyer's conduct here reflects a deliberate and reckless disregard for the lawfulness of that provision, right? I think that's what we're saying. Now, whether we don't want to say that is something different, but that's what we, I think, intended to say. And that because of that, it likely violated the duty of competence. And that's what we're saying. So if we think that we're not sure that the conduct does, or we want to qualify it further, that's sort of, I guess, the nature of the discussion, right?
Precisely.
And,
Yes.
Yeah. And I agree. I'm in, just my opinion is that I'm in favor of keeping it. I feel a little more comfortable too, making the change we made up above, making it clear that this is a material provision, and the other changes that the lawyer conducted no research or analysis. So I feel comfortable with it, but if we don't want to make it for other reasons too, I'm okay reconsidering.
Well, I'm not hearing any backup for my position here. So that being the case, I'm fine if it goes out for public comment and we can see if there are any comments on this sentence. And if so, we can take it up then.
And I'm sure we will receive comments, Justin, on that issue.
I bet we will. Well, with that being the case, Andrew, my understanding is our thought is to vote this out for public comment. And I don't know if you or others had a thought whether it should be or must be 60 versus 90 or what. Maybe you could fill us in.
Yeah, we're not stuck on rules. I'm sorry, on number of days in terms of a prescribed rule, but I think as you and the current members are aware, our typical practice for the first public comment period is to issue the opinion for 90 days. After an opinion's been out for initial public comment period, if we vote it out for a second public comment period, that's traditionally for 60 days. So following that protocol, I think a 60-day public comment period would be appropriate here because it's the second time this would go out.
Yep, that makes good sense. Well, if there are no further comments, I think that we should have a motion to vote it out for a 60-day public comment. Anybody want to make that motion? Toby's making the motion.
I'll second.
And I'm sorry, who initially moved?
Toby.
Toby, thank you. Okay, if there's not any further discussion, I'll take the vote. Justin Fields,
Yes.
Ken Bacon,
Yes.
Sarah Bonola,
Yes.
Elizabeth Bradley,
Yes.
Cassidy Chivers,
Yes.
Toby Inlander,
Yes.
Brandon Krieger,
Yes.
Joel Mark,
Yes.
Eleanor Mercado,
Yes.
Bill Munoz,
Yes.
Kyla Rowe,
Yes.
and Hunter Starr.
Yes.
Great.
All right. Awesome. Thank you, everyone. So we'll get our public comments back and have another discussion and hopefully finalize this opinion for consideration by the board eventually. So this is great that we've taken this opinion so far and made some significant revisions over the last few months. So thank you, everyone, for your help with that, and especially Dina and Sarah most recently. So we're a little behind schedule, but I think we should just keep rolling and try to catch up as best we can. Next on our agenda is a discussion of potential new opinion topics, which again would start with the possibility of issue outlines and, you know, getting those seedlings going for potential opinions down the road. So what Andrew's just shared screen with is a document we've gone over on several occasions over the last 6 or so months, trying to identify potential opinions for future discussion and drafting. One topic, to give you an example, that we came up with and is being vetted right now is related to in-house counsel issues. And so that's something that's in the works. We also have Hunter's issue outline on trial publicity that was in the agenda materials. And that came from one of our recent discussions on new topics. And then Kyle has also been working on an issue outline as well. But that's pretty much what we have in the pipeline. And so it's now a very good time for us to get a number of additional issue outlines in the pipeline so that we can start that next generation of opinions. And so, you know, Andrew, if you have some thoughts that you want to share on this particular document before we see if anyone has any specific topics they'd like to discuss or ideas that came out of reviewing this or other materials, let me know.
Sure. Just as a friendly reminder to the current committee members as well as our new committee members, staff will receive requests for the development of a particular opinion topic, and we collect those requests and we create a table, and you're looking at it. And when it's appropriate, based on the status of the agenda, as Justin just described, in terms of the workload of the committee to consider new opinion topics, we present this list, because part of the role of the committee when reviewing the request is if it's not a viable opinion topic, we will reply to the requester with a decline to opine letter. Sometimes the committee's not ready to shut it down, for lack of a better word, at the time of consideration. So they'll hold on to it to consider it at a future date. So this list is a mishmash of opinions we've considered previously that we did not formally decline to pursue, as well as, since the last time we've considered opinion topics, we did receive an opinion topic that's denoted here as item number 1. So that would be something that the committee would be considering for the very first time here. Of course, all the holdover topics are new to the new members. And then, notwithstanding the list of requests that we've received from the outside world, the committee oftentimes, and is free to do so, develops an opinion based on a topic that's comes from a member of the committee. So maybe if we could take a moment just to peruse this list. Some of it is long and lengthy. I know it's hard sometimes to formally say no to an idea. It also becomes a challenge because many committee members say, oh yeah, I remember we talked about this before, and they're similarly not motivated today to pursue it as much as they, in the same manner that they were previously, which was they weren't motivated. So that kind of depresses the conversation because we've already had the conversation. But all that to say, this first topic is new. And so if anyone wants to just take a brief moment to read it, and if there's a quick understanding amongst the committee one way or the other as to whether it's viable or as to whether it's probably not something that's worthy of the committee's time and resources to develop, we can attribute an appropriate disposition to at least this topic. And then however Justin wants to proceed, whether it's review topics we've looked at before or brainstorm on topics that the committee members might have themselves, we can proceed in either way.
Well, let's do this. Let's, since we've never discussed topic number one, let's do that first. I wanted to talk about at least one specific topic that's on this opinion request document that you prepared or others prepared, Andrew. And then I also have at least one idea that's not on this document. And then it would also be great to hear from others if there are any specific topics of interest on this document or outside of the document that anyone would be interested in noodling around the idea or formally starting an issue outline on. So hopefully everyone's had a chance to look at this first topic, and I have my own reaction to this and thoughts, but I would like to open the floor to anyone else first who might have a reaction one way or the other as to whether this might make a potential opinion for COPRAC, a viable opinion for this committee. Any thoughts?
My initial thought on this, Justin, is that this is definitely an area of law that I think is changing a lot, or at least is getting a lot of attention. And I see this kind of from the criminal side of it, where the criminal cases can be affected by this kind of problem, failure to advise about immigration consequences. And so I think it is something that deserves attention. And that's pretty much as far as I'll go, but I think it is something that we should probably give serious consideration to.
And could you give us a little more flavor, Hunter, on when you say that the criminal cases can be affected by the failure to advise regarding immigration consequences? Can you give us a little more flavor about how that comes up and what you mean by that?
Yes.
For the civil litigators in the room here.
So one of the things that California has really focused on in the last, I'll say 5 or so years, although it's probably closer to 10 now, is when an immigration attorney is working with somebody with deportation consequences, sometimes those deportation consequences can come from criminal acts. And in criminal acts of moral turpitude in immigration law is not the same as moral turpitude in, say, your standard kind of 1101A, 11 or 1B impeachment type stuff. So that by itself provides a number of, I'd say, ambiguities and vagaries that are difficult to navigate. But what will happen is somebody will, let's say, enter a plea in a criminal case, and we'll get to sentencing, and then they'll go to withdraw their plea, basically saying, well, look, I didn't realize that after I entered this plea and was sentenced, I'm going to get deported because of it. And so immigration consequences of criminal cases has kind of come to the fore, because that'll happen from time to time, even so much that the California legislature passed a statute saying that in negotiating, prosecutors shall consider potential immigration consequences when formulating resolutions. And so that hasn't been, I don't think there's much case law on what that's supposed to look like, but these kinds of, what do clients need to know about immigration and what their rights are? That is something I think that has at least been of concern to the California legislature, and is something that the legislature has taken steps to protect immigrants from such consequences. This question doesn't seem to be so much about the criminal aspect of it, but going over to the other side of the immigration side of it, I still think that California would see these kinds of advisals as really important. And the potential that an attorney does not properly advise, or let's just say that it's easy for an attorney to mess something up. And I don't know as much about the immigration side, but seeing it through the lens of the criminal side, I think it's something that deserves attention.
but that is a fascinating color that you just gave us that I think most of us civil litigators would not fully understand. And it definitely brings some more color to this issue. The other, a different side of it that you don't get from this, the description that I think focuses on the deportation attorney and whether it, well, anyway, I'll stop there. Thank you for that, Hunter. That's very insightful. I feel much more enlightened on this issue. I appreciate that. What are others' reactions to this?
My question, I mean, this might be my ignorance about immigration law, but in reading the description, in what circumstances, I guess, could a lawyer, if I'm reading this correctly, you don't advise the client of the right to admit or deny, and hence everything is admitted. Under what circumstances could a lawyer do that without discussing it with their client or getting client consent to admit the case against them?
Does it seem in the way this is phrased, and obviously this is coming from a person, this appears to be somebody who probably got a case where they're taking over and somebody had a prior attorney where they have at least said, my prior attorney didn't tell me all this stuff, which may be just a simple application of failure to communicate or failure of a duty of competence or what have you. I don't know that that's unique to immigration law, but I can say, at least in my limited experience with it, the specific type of advisals are not what I'm used to seeing in other areas of law.
Yeah, that was just my only thing, is it seemed like a kind of a no-brainer. You can't admit the client's case against them without the client's permission.
Well, it seems violative on its face of at minimum, 1.2 and 1.4. I think the requester's potential frustration, and I think some of what Hunter's describing is the ramifications for this type of failure is left in the civil context to either a malpractice claim, if that can even be brought after the person has been deported, or potentially an ineffective assistance of counsel claim in the criminal context, which again, not sure if that can be brought after the person's been deported. And so I wonder if the requester is trying to get an ethics opinion here, maybe to create or establish a basis for discipline liability potentially for lawyers in this area. Because my reaction is the same as Ken's. It seems fairly obvious the way they frame the issue that no, they should not be doing this. But is this pervasive enough? It probably is, but can we? I don't know. That's what I'm struggling with in terms of whether or not the committee should undertake the topic is where is it best suited to be resolved, and how is it resolved in either civil context or the criminal context?
What I'd like to do, Andrew, is I'd like to look into this because, as you kind of pointed out, if you lose a lawsuit because your lawyer acts ineffectively, then you can sue the lawyer for malpractice. But if you've been deported, that's a remedy, or at least that's a result that makes the following malpractice suit very difficult. So what I'd like to do is talk to some immigration attorneys and do some research on this topic and see if this does merit further detail, or if it's just a straightforward, sorry that you got yourself a really bad attorney. and it's just as straightforward, you can't do this, and the attorney violated their ethical duties. So I would like to look into this. I have a feeling if it did get to the point where we were writing an opinion on it, it would probably be a massive undertaking because this area of law is very complicated and kind of its own very specific specialty.
Right. And
Sorry,
sorry,
this
just really quickly, just to finish Hunter's point, his first comment was this area of law is changing and changes constantly. There are cases that I'm aware of that it is ineffective assistance of counsel to admit on the client's behalf that they committed a crime when the ramifications is deportation, and not tell your client, if you were to admit this, this could happen to you. So there is existing law out there with some aspects of this. And then the only other thing I'll note, Hunter, is this request came in with more than just these 2 paragraphs. So I'll forward it to you, and hopefully that will help inform the direction you go when you take a look into that.
I appreciate that.
and I'd be happy to
and-
help. This is Cassie. I'd be happy to assist Hunter. I've done some disciplinary defense for immigration attorneys on this issue, and I'm trying to recollect the issues that I wrote about, but I have those responses that may be helpful.
That's great. Thank you, Cassidy and Hunter, for volunteering to take a look at this. And I know some immigration attorneys as well. So depending on where you are with this, if you're looking to speak to some immigration attorneys, let me know, and I can try to connect you with a couple folks I work with who are very well versed in all things immigration. And the other thing about these the analysis that we do at this stage is that what we think might be the topic can evolve and can morph. And so as you're going through these issues, if you see subjects that might be better suited for an opinion that are different, maybe similar, but different than as it's framed on this document we're looking at, that's perfectly fine. The reality is a lot of these topics are framed in a way where we really couldn't draft an opinion on it for one reason or another, including some that have already been articulated by Andrew and others for this particular topic. So, if you're striking out on these particularly framed issues, but you see others, let's continue to have this conversation. And it ultimately seems to merit at least an issue outline for purposes of our next meeting. That's not until December. So we have some time to consider this issue and potentially put something down in writing to discuss with the group in a couple months. So that's I think that's the right next step here, looking into it and then deciding if it merits an issue outline, whether it's this particular issue or something that morphs from it. Anything else that anyone wants to talk about on this topic 1, or can we move to the next? Go ahead.
I just wanted to let Hunter and Cassidy know that I also have a very good referral of somebody who's been doing work in this area for a long time through Public Counsel in Los Angeles. It's a big nonprofit law firm. Some of you may be familiar with it and probably could be helpful.
Thank you. Well, one of the opinion requests caught my eye, and we had briefly discussed it, I think, times ago, and so I wanted to raise it again. It's topic 103, Andrew. The cryptocurrency, Bitcoin, all that. And I was just noodling around the internet trying to see what's sort of the status of ethics opinions on this subject. And I did it very quickly, so maybe I missed something significant, but I didn't see much. I saw an opinion from Nebraska in, I think, 2018. I saw some articles from 2019, one from the CLA and one from the ABA. There's a DC ethics opinion that's fairly recent, but I didn't see much else. And it's I think a fascinating system of currency, and it implicates a number of issues, unconscionable fees, safekeeping, safeguarding client funds, and things along those lines. So it seems to me like there might be some fact patterns in there for us to play with, some issues that and wouldn't necessarily be treading ground that's been tread many times before. How do people feel about that? Are they aware of some other opinions that I might have missed that makes an opinion from COPRAC duplicative, or do folks think this might merit at least an issue outline?
This is Ken, I'm not aware of any opinions, but is this really a thing? I mean, are law firms taking Bitcoin as payment for fees?
It
Yes.
is a thing.
Oh,
It is a thing. It's such a thing that our insurer, who holds a very big conference every year and has very, very professionally done, like a symposium like we do. So there's like 4 panels. One of those 4 panels, and they get the big hitters to come on these panels. One of those 4 was on cryptocurrency. So,
interesting.
having that panel with hundreds of lawyers who are just like all of us, interested in legal ethics and professional responsibility. That's the audience. That's what they did, and that to me really showed that this is mainstream. It is something that people in this industry are thinking about quite seriously. And so, yeah, I do think it is something that is happening, and something that I can say at least law firms are looking at carefully.
Yeah.
My fee arbitration brain is spinning. I'm trying to imagine a fee arbitration payment in Bitcoin. We'll have to do a new advisory when that happens.
I will say in Los Angeles, we had it might still even be on the docket, an opinion in committee for about 3, maybe even 4 years now, at least 3 years. And that committee is around 40 members. And we just had a lot of really seriously conflicting and diverging opinions that it just kind of got stuck. But I mean, I think that the more time passes, the more important the subject is, because it's not this kind of random thing anymore that some fringe people are doing. It's becoming more and more mainstream. Large firms are accepting cryptocurrency. There's been so much press about the extreme volatility lately of different forms of cryptocurrency, which, triggers a lot of the ethical considerations if lawyers who are not particularly skilled or educated on how to handle cryptocurrency, are they complying with their ethical obligations? I think it's important. We were taking I think everybody was pretty much in agreement. We were taking a position opposite of Nebraska. I don't remember the specifics at the moment, but there was definitely a place, kind of a need in the marketplace for an opinion on that issue. That was my thought. And so I really hoped we put something out. There've been a lot of articles in LA and elsewhere, including there was a big article on the cover of LA Lawyer, and I think they did several in a row, several months in a row, which leads me to believe that it must be a topic of interest for a broad range of people. So I think it's worth exploring.
Yeah, I feel the same way, Elizabeth. I think that this, at the very least, merits an issue outline for us to work through as a committee. And so I would propose that we prepare an issue outline for this. I'm happy to work on that issue outline if anyone else is interested in helping out with that. That would be great as well. And then hopefully with the goal of having that issue outline ready for our December meeting.
Justin, I'd be happy to help out with you.
Was that Bill?
Was that,
Yeah, I'm happy to help out.
Thank you.
I'm
And
just doing a quick search here. There's something that's, I find this fascinating. The North Carolina State Bar has, I think it's an opinion, I'm not sure from looking at this. Is it ethical for lawyers to accept Bitcoin and other cryptocurrencies? It might be an article, not an opinion, but. So there's
There's a
some,
New York, there's a New York City one too. I know I've read that. I think there are 3 or 4 out there that I'm aware of.
I mean, I think it raises so many kind of fascinating issues, like, is it property or is it funds? Can it be funds if you can't put it in a bank? And what are the safekeeping obligations? And when do you evaluate the value of it? As far as determining unconscionability, and is it a retainer agreement, a pure retainer, and hourly, or, you know, there's so many, it's kind of like, it really triggers a lot of issues.
Yeah, it
Issue
occurs to
spotting
me,
bonanza.
Mm-hmm.
it occurs to me also, just as one aspect, if it's a deposit against future fees, then when do you value it? So,
And who bears the risk of
Yeah.
the fluctuation in the value? And when do you determine unconscionability? The time you contracted, or later when it's fluctuated drastically?
well, wouldn't informed written consent address some of the unconscionability factor? I mean, both sides would be taking the risk that this is volatile and it can go up and down. I mean, there are other forms of property that can be provided to the lawyer as payment, and it could be a piece of property. It could be something else that might shoot up in value or go down in value.
Mhm.
And that's not to say, of course, cryptocurrency is much more unique than an old-fashioned car, or, you know, a plot of land in Iowa, whatever it might be. But all the, you know, I think it's similar and analogous in nature. But man, those other questions of, yeah, stick it in an IOLTA account, or what else you got to do with it? Yeah, that has an ethical overtone, and that's interesting to me. Some of the other questions are just so challenging, and it might not be ethical in nature, but that's not to say, I'm not at all trying to discourage in any respect that we look at this, but.
well, Andrew, I would disagree with your first premise, because unlike an antique car or piece of property, if it's being held in trust, you're just allowed to levy against that property and realize the dollar value out of that property. Bitcoin is kind of somewhere in the middle. It's a currency or not a currency, and I think there's an ethical look-see that has to be given to it, beyond just that it's held like any other piece of property. And I'm not volunteering to do it. I'm just saying, I think it's time we kind of entered the 21st century world of cryptocurrency and do the best we can.
I think I read that some governments are actually accepting it for tax payments.
Yeah, I think it was El Salvador.
Yeah, isn't it the currency of a South American country now?
Yeah, I think you're right.
National currency.
Yeah, it's El Salvador.
I anticipate that there's going to be a tendency to get into best practices discussions, though, when it comes to it, because of, among other things, the extreme volatility. But it should be interesting.
yeah, the San Francisco Bar Association has also been considering this as an ethics opinion for, I guess, several years now. And one of the members of the committee actually drafted a really, really great article that I can share with you, Justin, on it. But we were kind of debating whether to do it as an opinion or CLE, and it just, for some reason, it just didn't move forward. I'm not sure what the current status is. I've missed the last few meetings, but I don't know if Cassidy knows, but I'll try to get some materials that we worked on, like some of the supporting authorities that might help you.
That's great. Yeah. If anyone has materials that they think would be helpful background, please forward it along. And if anyone else wants to help out, great that we're generating this kind of conversation on just potential topics. I know Bill and I would welcome anyone else who wants to help gather information and prepare an issue outline. So, the more the merrier on this. We're a little behind, so I look forward to further discussion on cryptocurrency as we move forward with this in December. What I want to do next is hear from if anyone else identified topics on this opinion request form that they might propose for an issue outline. And if not, then we can try to brainstorm off of the list. But let's try to complete our discussion of the list first.
Justin, just real briefly, 105, it's a case, was a request about a Washington state case that an in-house lawyer negotiated apparently a 16-year severance provision. And the issue arising out of that was that his wages or was it his fee? And the Washington court apparently said, no, those were wages and treated him that way. There was a case that came out about a week or so ago, which I just happened to read this morning in California, which took the opposite view where the lawyers, in-house lawyers' compensation had a bonus contingent upon the performance of some aspect of the corporation's operations, but it wasn't in writing, it was oral. And so the question went off on, was it required to have been in writing under 6147, or was it a wage agreement, which could be oral? And the court held, no, it's an attorney fee, even though it's in-house counsel. So it's in direct conflict with this case cited in 105. So I don't know if it merits a whole opinion or whatnot, but I just wanted to point that out. I give you the case, but I already filed it away. I'll email it if somebody wants it.
So, Joel, thank you for bringing that to our attention. I don't mean to put you on the spot, but do you feel like there would be enough from an ethics perspective to draft an opinion on that California case and its implications?
Well, if you give me till December, I'll just take a look at the two cases and see if I see anything broader in them, or what I'll do. I'll just come back with a report, not necessarily an outline.
Okay, yeah, if you think it merits further discussion for a potential opinion, great to put together the issue outline so we can all look at it. And if you decide, by golly, it just doesn't merit it, even just a small report on that so that we can reach a disposition on this one officially, I think that would help us as well. So either way, some form of work product would be great. And just, in terms of our ethics opinions going forward, it's fine and dandy that we have these detailed and lengthy, comprehensive opinions, which we've put out over the last few years. But if we also have some that are very short and to the point and just address an issue or two, I think that's something that we can and should consider, to Brandon's earlier point. And so if this is one of those where you see a really interesting ethical issue come out of it, but it would only be a 5-page opinion, maybe that's okay. And it's something for us to discuss as a committee. So I just offer that by way of background. Thank you, Joel, for volunteering on 105. Are there any other topics that stood out to anyone on this document that we should discuss?
10AA was something I had brought up at one point. I'm not prepared to expand upon that today, but I'd be willing to do a little more research and put together an issues outline. As I generally this is something that's brought to my attention a couple of times. It's in a situation where employers and labor unions can negotiate what's known as a carve-out agreement that basically takes them outside of the workers' compensation system. And if I understand correctly, the way it was described to me, the lawyers who were representing the unions and negotiating these agreements also wind up acting as some sort of ombudsman mediators of the claims. And it struck me at the time as something that was presenting some potential conflict and issues. I said I'm not prepared to explain it more thoroughly than that, but I'd be happy to try and put something together if I think it's something that might be worth further discussing.
That's great. Thank you, Ken. And I would say same that I mentioned to Joel. If you think it warrants some issue outline, we could share that and then have a discussion in December. Wonderful. If you don't think it ultimately merits even an issue outline once you look at it more closely, if you could still prepare something very short and simple for the committee to take a look at, and then that way we can reach a final disposition on this one and knock it off the list if that's the route we end up taking.
Okay. All right. I'm just going
Any other
moving forward too. And now that I've gotten past some trials and stuff, I will get back onto the flat fee thing that we were working on. So I should have something for December on that.
Thank you.
I'm also curious about
Any
here,
other
9AA. What was I really hate the Cassell case. I'm curious what.
I love that case, Ken.
Oh, okay. To each his own, I guess. But I don't know who raised this, and was there more to it, or the mediation confidentiality?
I'm not sure either. I think this preceded the statutory change, which now obligates the disclosure. So this might not be an issue any longer unless we wanted to develop a fact pattern or a short hypothetical analyzing, I don't want to say best practices, but how to comply with the statutory obligations in terms of disclosing the airtightness of mediation confidentiality.
Yeah, I was just curious because I agree with you. I mean, the disclosure seemed to clean up a lot of the.
Yeah, I think this preceded the
issues.
statutory change. I'm sorry, I don't have a date as to when that request came in. Does anyone feel strongly about this? I mean, we can take this off. It does help to cull the list.
I would call it, given the evidence code.
Cool.
Any other topics on the sheet that folks want to talk about?
I think it's it's higher up on the list, but it's the Meredith case. I think it's listed as number 1.
Yep, I'll get there in just 1 second.
Number 8.
8, thank you. I'd be interested in taking a look into this. The Meredith case was, of course, I think is fairly well known in terms of what the requirements are, but I think that maybe we could have something to say that might elucidate it a little bit. I'd like to look into that.
Hunter, and I would say, I won't repeat myself, but same comments that I made to Joel and Ken. Just looking on the face of this and not knowing anything about People versus Meredith, I think the challenge on this topic will be extracting ethical issues to address in an ethics opinion, as opposed to getting into best practices or statutory obligations or obligations arising out of case law. So be interested to see if you're able to identify some ethics issues that could take up an opinion and not get overly bogged down in otherwise statutory or case law obligations in terms of turnover obligations and disclosure obligations.
Right, right. Thank you.
Any others? This is fantastic. We have not had this many issue outlines going or potential issue outlines in a long time, and that this is the time is ripe. So
I had something that's not on the list.
Yeah, let's go there.
It was just brought to my attention the other day. I hadn't seen this before. It was posed to me, by another attorney, is this ethical? And what the situation was that, and I was shown a few examples, evidently you have lawyers, let's say there's a massive car accident, and lawyers are writing what appear to be a news article about the accident. So if somebody goes on to, Google and searches, accident December 10th, 2020 at such a location, things pop up that look like a news article. And when you click on it, it takes you to an attorney's website. I hadn't seen that before. And the question was, is this some sort of, runs afoul of solicitation or advertising rules? It looked pretty shady to me, because what was shown me by another attorney was, like I said, it looked like if you're just doing a Google search for something and the news pops up, and next thing you know, you're on some attorney's website where they're offering their services. I don't know if anybody's seen that or heard that. And off the top of my head, I didn't know the answer to the question, which was, is it ethical? It struck me as problematic.
Well, it seems to me it's already covered by the, for the purpose of seeking employment requirement in any advertisement. If that's what you're doing it for, and that's where you end up with the ability to employ the lawyer, I think that's kind of already covered by the existing rules, but that's just my view.
I think that we run into the issue of because those are essentially blogs, right? They're usually going to be in the form of law blogs. Here's this thing that happened, but it's on the attorney's website. And so I think we might run into the problem of perhaps kind of telling or getting to a point where we're telling firms that they shouldn't be performing law blogs that include news. And I see your concern, because it's almost underhanded, right? It's, here's a news article, but really we're trying to sell you a service. But at the same time, I think that law blogs are so popular. When I've seen news articles kind of on an attorney's webpage or a firm's webpage, it's usually in the guise or an actual substance, a law blog, and it's there more or less to inform people of their rights or the services of the firm. So I think it could get tricky getting into that.
Yeah, the ones I saw, that was, because I thought about that too. What popped up, the attorney showed me on Google, nothing appeared like it was a blog, nothing indicated. The names of the links would not suggest a law firm. I don't want to say any of them, out loud here since we're in public, but it just, it just struck me as deceptive, because you think, if you're just perusing something, next thing you know, you're on a lawyer's website and they're advertising their services for that particular, incident. So not a burning issue, but I still I'd throw it out there. I had never seen that before, and it struck me as at best a borderline practice. Not sensing a lot of interest, though. All right.
Well, the solicitation advertising hypotheticals are always interesting. But doesn't sound like we have any takers for this one, but I thought that was an interesting fact pattern that you just presented. So thank you for that, Ken. I was just perusing around other jurisdictions to see what they've been writing about, and one topic that I thought was interesting and the opinion well done was from DC, and it was addressing serving as, and it came up recently in something I was dealing with, and the question was serving as counsel to an entity client and also serving on their board, and the ethical implications arising from that, which I think you can imagine are things like conflicts of interest, imputation issues if you have your law firm performing some of the work, the organization as the client, and some other issues. And I did not look, and maybe Andrew knows because he's our repository of California ethics knowledge, if we've covered that issue in any prior opinions. That is serving as counsel to an entity client while also serving as a board member.
COPRAC opinion is not coming to mind off the top of my head, but I'd have to conduct some research.
I know in my experience, most professional liability carriers have questions about that on their application forms. And I know many have fairly strong policies, about attorneys engaging in that.
That's right. It's a hot topic for insurers. I know every year at my firm, I have to check a box or boxes and indicate if I'm serving on any boards. And if the answer is yes, that takes you to many more boxes that have to be filled out, right? So it is an area rife with ethics issues, and the DC opinion 382. I think handled it well. Does that occupy the space as a result? I don't know. I don't know if we would reach a different conclusion or have a more nuanced discussion than that opinion. But it does seem to me to be to have the potential for a fact pattern that has all sorts of interesting ethics issues for us to consider. So that's just one I wanted to throw out there to add to the list as one that maybe someone might be interested in looking at further and preparing an issue outline. But I certainly don't want to preclude other thoughts if others have ideas that they're interested in and want to discuss now. No? Any other thoughts? Anybody ecstatic to look at the serving as counsel to an entity that you're on the board for? No? All right. Well, this has been a very fulsome, I think, discussion of new topics. I'm excited that we have so much new material to talk about in December, and hopefully some of these will spawn new opinions for us to begin drafting. Before, I'm thinking we'll take a short stretch break and then move to our next topic. So any final comments, questions, offers to look into anything on new topics before we take a few-minute break? Okay, well, why don't we take 5 minutes, and we'll start back up. And Andrew, I think that would be a good time to talk about the paraprofessional rules.
Sounds good.
All right, so let's take 5 minutes. See everybody back shortly. So Andrew, looks like we have almost everyone. Why don't we just give everybody a few more seconds, and then we can jump into paraprofessional rules.
Sounds good. Eleanor, are you back with us? I'm only asking because you're the one person I can't see.
Sorry, I was on mute. I am. Thank you.
Great. Yeah, no problem. Not trying to put you on the spot, but didn't want to lose you. Okay, so as I mentioned during the staff report, which feels like it was 3 different Zoom links ago, the Board of Trustees has issued a report for public comment concerning the development and potential implementation for a paraprofessional regulatory program or paraprofessional licensee. And as part of that report, a component consists of proposed rules of professional conduct. And so the question for the group is whether we would like to issue public comment on any of those rules. And they're generally all modeled after the California Rules of Professional Conduct, which I should know. I think it's 70 rules-ish, but they've added a rule. So the proposed set for paraprofessionals might be 71. Something is, I have a hankering that my number's off by 1. I don't think I have the total right, but approximately 70-ish rules. And that would be a lot for us to go through. And we are, if we wanted to opine on a rule, we could submit comment on any rule, but I try to create a table to at least narrow down the focus, because most of the rules are the same, or even those that are not the same just have minor or minimal differences. And some of the rules that are more significantly different, I try to highlight in blue in the agenda materials. We don't have to go through this list here for purposes of this discussion, although we certainly can if anyone has questions. But one way to do this efficiently would be to ask the general question, do we want to opine on the rules? I guess that would be answered by probably having someone take a look at the rules to see if there's something to opine on, which I imagine at a minimum, you might want to do that. If that was the case, we could use some volunteers to create a small subcommittee or working group to look at these rules. My recommendation for looking at the rules would be to review them for 2 reasons. One would be to review them to see if they got it, any revision correct. Just and when I mean correct, like, is it written appropriately in terms of a rule of discipline? They model the rules of professional conduct for attorneys. So is there anything that they're in their drafting style or their approach that is either wrong under the law as it applies for attorney conduct, or is drafted in a manner that's not appropriate for a discipline standard. That's one thing to consider, which I think would be helpful to the working group should we see any of those things be present. The next thing would be if we wanted to opine on any of the policy components of it. And I think that would be a helpful way of framing this task. And I'm happy to talk about any of the particular rules if anyone has questions about them, or again, depending how Justin wants to lead the conversation. One way to go would be if we could have 3, I think 4 persons would be a good maximum number of people to consider for this task. And then maybe that group of 4 could divide up, at least start with the rules that are highlighted in blue, in 2 teams of 2, or however you wish to do it. And if there's something to be said about these rule revisions, a public comment letter could be drafted for the next meeting, which is in December. And the public comment deadline concludes on January the 12th, which is a Wednesday. So I think our meeting, if I'm doing my math right, is on January the 9th, which would be the last meeting for us to approve a letter in order to submit it for consideration in time. So we also have samples of public comment letters that the committee has drafted previously over the years, and Mimi or myself can share those with any of the volunteers in terms of how to frame such a letter.
Andrew, this is so I have a question, just sort of a threshold question, which is that the attorney rules of professional conduct sort of are intertwined or sit on top of a body of law giving attorneys fiduciary duties to clients. And I don't have any understanding as to whether or not these paraprofessionals will have fiduciary duties. And I think that is kind of a significant issue, because if we just track the attorney rules, which operate in a fiduciary duty world, I don't know, do we have any clarity on whether these paraprofessionals have fiduciary duties?
I don't know that off the top of my head. My sense is the expectation is yes, but I don't know that. I mean, certainly there's the same rule 1.15. So fiduciary duty in that capacity in terms of civil law, I'm not sure. I think, this has to be created by statute as well as rule of court. So that question might still be developed. And my sense is the intention would be that yes, absolutely, that would be the case. My only hesitation is I'm not familiar enough with the report to point you directly to what page that statement's contained on.
Would it be?
I think.
Well,
go ahead.
Would it be appropriate for us if we do a comment to? Are we limited to just talking about the rules that are in front of us, or can we suggest requirements of fiduciary duties or things of that nature as well, if we think it's prudent?
Well, my recollection of the B&P Code 6500, I think it is, which is what governs paralegals. I can't recall any specific fiduciary duty, but on the other hand, attorneys have to supervise paralegals or paraprofessionals. They can't operate on their own. And the attorney's fiduciary duties certainly would carry over. And part of the attorney's fiduciary duties would be to make sure that the paraprofessionals respect them. So I think it's not just as simple as to find a statement that, yes, they are or aren't fiduciaries.
Well, so Joel, you're right with paraprofessionals. This will be slightly different. Paraprofessionals will be able to operate independent of the oversight of an attorney in a limited areas of law. with limited prescribed tasks. So it'll be slightly different than what you're
Well,
describing.
then all the more is important for us to address the issue of what fiduciary obligations they would carry over as if they were looking for an attorney.
I mean, I think, so to answer your question, Brandon, I don't see why we would be prohibited from, a general introductory paragraph. I should probably look at the report to make sure that that's not addressed there. So we're not raising something that's already been addressed. But if it's not addressed, the observation you've raised is, in my view, pertinent and germane to the rules of professional conduct. And so that simple observation, I'm sorry, I don't mean to call it simple, but that narrow observation, absolutely.
Not
I don't see
offended.
a problem with that being, with that being shared.
Hey, Andrew, did they, because you and I had talked about this, did they address the, because since COPRAC now has our fee arbitration context, fee arbitration and whether paraprofessionals would be subject to fee arbitration?
Yes, in the report, they would recommend that the legislature make an amendment to 6200 to include paraprofessionals to be subject to the Mandatory Fee Arbitration Act.
Good.
Well, I think it's a no-brainer that we want to comment on these rules, and that this is clearly within our mission, and that we would be expected to offer our input into these rules. And just hearing the initial questions and comments, I think highlights why this is the right committee, obviously among others, to provide input. So, Andrew, let me ask you, as a matter of procedure, can we just solicit volunteers to be part of this subcommittee that will put together a draft comment letter for the committee as a whole to look at in December, or do we need to vote first to create that subcommittee?
Volunteers would be best, as a reminder for our existing members, and as informative for our new members. The committee's operations are subject to Bagley-Keene, and so any formal creation of a subcommittee that is 3 or more persons would be subject potentially to Bagley-Keene requirements, such as publicly noticing meetings 10 days in advance. But if folks volunteer on this effort to develop something to bring back to the committee for its full consideration, that would not be subject to those requirements. And I think that would be prudent to go in that route. So 2 options: the chair could appoint teams of 2 or fewer, or we could get volunteers of less than a quorum of the full committee to avoid the Bagley-Keene notice requirements.
Understood. Well, I think it makes sense to see if we have 3 or 4 volunteers who would like to work on preparing a draft letter for the full committee's consideration in December, along the lines that Andrew outlined, looking at the rules of for paraprofessional conduct. And so with that, let me ask who would like to volunteer to work on this for our next meeting?
This is Eleanor. I'll volunteer.
Who is that?
Eleanor.
Oh, Eleanor, thank you.
Thank you.
Justin, I'd be happy to help out going through with them and discussing them. I will be out of the country after November 17th for several weeks. So I have a 5-week window or 6-week window to help out with it before I take off.
Great. Well, I mean, I think it would be wonderful to have your perspective, Toby, as the public member So that would be great to have you participate while you're available to do so. Any other volunteers?
I have the same concern because I have 2 trips between now and our next meeting, but I'm happy to volunteer and do as much as I can.
I appreciate that. That's wonderful, Elizabeth. And we'll have 2 months roughly, so I think that gives us enough flexibility to find pockets of time where everybody's available, or most people are available, and try to divvy up the work so that it works out for everybody and nobody's working on their vacations or with through other scheduling conflicts. So that's great.
I'm happy to volunteer too. This is Cassidy.
Cassidy, great. And then just on the leadership side, Sarah and Dina have been doing so much, and so I'm happy to offer the support from the leadership side to these volunteers, and so we can touch base after the meeting and try to set something up for the volunteers to start looking at these rules. Now, Andrew, I know that you circulated some other information related to the paraprofessional rules and the link that's within your memo. Is there anything besides the report and recommendations that you think this subgroup of folks should be looking at that would help inform their review of the rules that's not already contained in the agenda materials?
No, I think those are the main pieces. So what I'll do is work with Mimi to get a couple sample public comment letters that the committee has submitted before. And I'll include this table in the hopes that it's helpful in terms of focusing the volunteers' efforts on at least these initial rules to look at. I think it's hopefully pretty agreeable that these are the ones that would necessitate a close look initially. And then the set of rules that are shared is a clean version of the paraprofessional rules that are being proposed, and a red line as compared to the attorney rules, so that you can see precisely what changes are being made. And I do think the main report would be helpful as a resource, a consulting resource, should it be necessary. If you might have questions, they say, oh, they're not doing criminal law. Why is that? Maybe you could go, not that it might be self-evident to you, but there are other decisions that are referenced in the rules that paraprofessionals will not be undertaking certain areas of law, and consulting the full report might be helpful in getting you an understanding of why that decision was made.
Excellent. And this document that we're looking at, that Andrew and perhaps others prepared, is just a great example of the support that we get from the State Bar and its team, putting in some legwork for us, a lot of legwork for us to identify issues and help with our analysis, and it's very appreciated. So thank you for putting your memo together, Andrew, and this chart, and it really helps get the ball moving in terms of what you want us and what we should be focusing on with the draft letter. So much appreciated.
No problem.
Anything else that anyone wants to talk about related to the paraprofessional project that we have now? All right. Well, then let's move on to our next item, which is Hunter's issue outline on trial publicity. So, Hunter, maybe you could give us, in particular, our new members, a little background on the genesis of this issue outline, what you've been looking at, what you've found, where you are, where you think you're going, all that good stuff, for those who are not as familiar with what you've been working on.
Sure. So as I mentioned earlier, my wheelhouse is criminal law. As a prosecutor, I'm usually up to speed on current events. In 2020, there was obviously a lot of fervor with regard to the criminal law, and it has really become a central focus in California, I would say, where law meets public perception. In Yolo County, there was something that interested me, in which a couple of publicly employed defense attorneys made allegations publicly regarding racism, basically saying that they on a daily basis see racism employed by prosecutors and judges. And this, I would say, started kind of a public feud. And I don't think feud's the right word, but it was definitely high profile sparring between the Yolo County District Attorney and just kind of the, well, you know, if you're telling us we're doing these things, which would be illegal, we want to have a broader conversation about that. And the one thing I notice about public and trial publicity type cases, they tend to be about prosecutors making public statements that deride people they are prosecuting. It's also seen in the civil context, but I find a little bit less so. So the question arose in my mind is making public statements with the intention of essentially polluting the jury pool so that they will be more cautious or less likely to see prosecutors as credible based on allegations they've heard. Is that something that is governed by 3.5 or 3.6? This is partially because 3.5 has had an opinion, at least one opinion, basically saying, and this is something that most prosecutors are informed of early on in their careers, you can't go to a juror and say, hey, this is what you really didn't get to hear, because that would be generally considered polluting them and trying to influence further jury service. And on top of that, as a trial attorney, over the last 8 years, I've noticed a much higher number of jurors or prospective jurors come into the courtroom and start with kind of the preconceived notions of, well, we know that there's these, you know, systemic problems. And part of that is good because in California, we're very concerned about eradicating systemic injustices. But at the same time, I'm noticing more people being removed from juries for cause because of the, results of these public statements, the preconceptions that are developed because of them actually cause these jurors to have a difficult time being fair and impartial. So that's kind of why I wanted to look into this. And I recognize a few of the potential pitfalls of discussing this. One is everybody, I think in this committee is on board with trying to make the system better at all times. So any statement, public or otherwise, that is intended to improve the justice system, I think we would look at it as an affirmative good, and we don't want to chill that. Moreover, we have the potential First Amendment issue that we want to be careful around. That being said, I looked into this with kind of uncertainty as to whether 3.5 or 3.6 would be the better framework to analyze this type of issue. And it would be essentially statements made in order to prejudice a prosecuting agency in specific litigation. When I looked at 3.5, I looked at about 30 or so jurisdictional different language in their ethical codes, and they're all pretty much the same, except for some minor language. Generally, 3.5 goes only to the jury that sat in a particular case. the broadest it could be viewed is essentially the jury pool from which that jury was pulled. So I think that general statements to the public that would be fashioned in order to prejudice a party could not really be analyzed under 3.5. It's just not meant for that. It really is for targeting a specific juror in order to, I'd say, harass them in a way to change their future jury service. So I took a look at 3.6, and my overall opinion is that if there's something so clearly intended just to prejudice a party, then 3.6 is the correct framework. Mostly I noted that the case law doesn't really help us. And this is partly because prosecutors generally don't appeal. It doesn't mean that they can't appeal. There are instances in which they can appeal, but generally they're not going to be able to appeal a decision and claim that there was some pretrial publicity issue. So that's not going to be very helpful. The scenarios that I came up with were designed to kind of parse out the different issues and make it clear that supporting affirmative and positive change in the system is not what we would be looking at here. That being said, having gotten through this outline, I'm not convinced that we have something that doesn't just amount to a very simple, you're not allowed to go out and purposely prejudice a party. That's just a simple application of 3.6. Whether that's actually happening would be just a factual issue in any given instance. So I'm not convinced that this should be an opinion. That's where I am.
Thanks, Hunter. Appreciate that background and kind of giving us your 2 cents about where you think this might be headed or not headed. That's helpful. Let me ask you a question. Did you see or have you seen in any other jurisdictions how they've applied 3.6 or their equivalent, and whether any other opinions or cases or elsewhere have addressed anything like this that might provide any guidance?
Not that I've seen. Generally, what I found tends to be focused on prosecuting agencies, making sure not to make specific statements about specific criminal defendants. And I don't think that provides a very good analogy, because that individual has maybe 1 or 2 cases. And so that would be very clearly prejudicing that individual who has Sixth Amendment rights. Whereas in the instance of a prosecuting agency, you're dealing with the concept of attacking a public and elected official on how they operate. And so I don't think that that's a particularly useful analogy. I did not find any other opinions that I found particularly useful.
Yeah, I'm glad you raised that, the fact that the example as to how this might play out from the prosecutorial side, because when I went through the scenarios, they're obviously all focused on criminal defense attorneys. And so where my mind went was, well, if we were to have some kind of fact pattern that was on the other side, in the context of a prosecutor, what would that look like? So it sounds like that would probably focus on statements related to an individual defendant, which really isn't analogous to what you're exploring with on the criminal defense side. And so that leaves me wondering, in terms of a more balanced opinion, looking at both sides, whether we could come up with a scenario that involved the prosecutorial side, or would we even want to do that if we were to pursue this further?
I think
what are your thoughts on that?
That's definitely possible. The reason I didn't get into it much is because I think that it's essentially well-traveled ground. With the existence and comments of 3.8, and plenty of case law basically saying you don't get to get up and make, prejudicial statements like this. I think that would, if we were to formulate an opinion, that would be background information. If we were to develop scenarios, that might be helpful as well. It would lengthen the opinion and it might provide new light. Mostly the reason why this came up in my mind is because I didn't off the cuff know what the answer was. And I feel like we're working in negative space. Whereas I feel like I have a pretty good idea of what prosecutors would be allowed to say. But I think the comparison must needs be drawn. It would have to exist within an opinion. This is what exists. This is what the law says. This is what ethics requires, because that's all we really know. So I think it would be necessary to any opinion.
That makes sense. My other reaction to this, I agree with you. There are promoting improvement in public justice is what we all support, and that there are serious First Amendment issues that we would need to navigate in analyzing these scenarios. But ultimately, I was curious, what tentative conclusions you would be reaching from these 4 scenarios, and because what those conclusions are, I think would also inform how the committee views this topic and whether it really would be something that we wanted to delve into and publish something on or not. And I think I have a sense of where you would go on the conclusions, but I don't exactly know. And I think that would be something of interest and might require some more analysis in an expanded outline. But really, I'd like to hear from other people whether they think that if they have the same instinct as you, Hunter, that this would be a challenge to pursue, or whether others on the committee see a benefit to pursuing this further and maybe expanding the outline to provide some more analysis and tentative conclusions before we make a final decision as to what to do with this issue outlined. Nothing? Well, what do you think, Hunter?
I mean, in terms of my conclusions, when I was writing them, I felt 1 through 3 were all, they're all pretty much permissible. 4, I think, is on the cusp. I think there's a difference between, this is part of a defense, or this is clearly targeted at reformation, or this is using specific data to encourage reformation, versus the general statements that a certain agency cannot be trusted. And the reason I use agency as the term is because, 1, all prosecutors are fungible. So, Hunter Starr versus, Bob Smith, it doesn't matter, right? We just stand in the shoes of the elected district attorney. And so to attack the office of that particular person is essentially to attack a party, right? To every item of litigation. This is why prosecutors never make it on the juries, especially because in criminal cases, there's a presumption of bias because we represent one of the parties, even if not in that case. And so in number 4, I felt like that was the only one that would really be worth struggling with, which is making assertions that a prosecutor makes race-based charging decisions, which I think would essentially be a public assertion of an ethical violation, and something that might prejudice a jury and get them questioning. But at the same time, if a prosecutor is making race-based charging decisions, you kind of have to point that out in public, right? They're elected officials. So I think number 4 was the only one that might cause any kind of in-depth discussion that could go either way. I think the first 3 are pretty much bright line, this is acceptable.
Okay, well, you know, there's always that naughty KNOTTY scenario that we work through as a committee. So it doesn't surprise me that at least one of these would be more challenging to consider. I mean, look, the bottom line for me is with Rule 3.6, I think we all feel like we want to reach a conclusion that Rule 3.6 does not, you know, impair or impede lawyers' ability to promote, you know, better public justice, right? And so at the same time, I think that the subject matter here is probably going to generate a fair amount of public comment, which is not a bad thing per se. It's a serious issue, and it's one that I think when people, if we were to pursue this, it would get a fair amount of attention. And so I think we would want to address it carefully and be thoughtful with the conclusions we reach, and in particular, maybe with scenario 4. So I think it would, we would need to look into this further with an expanded outline, I think, as a next step. Does anyone else have any thoughts or comments?
Yeah, I just, not practicing criminal law, of course. This really reminded me, because I'm not watching the People versus O.J. Simpson with my son right now, but like a lot of these things have, of course, came up in and with respect to that case, which everyone's very familiar with, and the way some of the defense handled certain comments they made about, you know, race relations. And obviously there was racist cops involved in that, but then the question being like, was he targeted based on race? And, you know, and the way that the media was used, manipulated, exploited, however you want to say it, by a lot, in large part the defense, but certainly both sides. But, you know, and there were allegations, very general allegations like you're describing here, against the district attorney's office in general, that was like their policy, and that there is, so, I mean, it's just an interesting, I don't know what, you know, what you think about that idea. I mean, it sounds like you're saying like a general sort of indictment of the DA's office is basically suggesting, you know, to potential jurors and jurors who are going to be impaneled, that's always their policy, and that you have to discount any, you know, testimony by a police officer that's part of that department, or any prosecutor that's prosecuting a case from this office, because this is their, you know, and is that, you know, again, not to suggest that racism doesn't exist, but to suggest that as a way to get your client off, where that may not be really the issue. I don't know. I mean, I think it raises an interesting issue, and I'm not sure in context of that case, which is familiar to people, but it doesn't feel like there's an easy answer to that. And I agree with Justin that it's sort of treading on difficult territory, which you've already identified in your outline, which is to suggest that, of course, if there's like policies that are, you know, targeting particular groups based on race or socioeconomic status, and types of crimes that we're charging more often that affect certain groups, whether they're, you know, as opposed to other crimes, then that should be discussed and called out, right? I mean, and maybe it's a way to address that issue, but I just was thinking like, that's really a complicated issue, right? Because I didn't feel like it was appropriate the way the defense handled that in that particular case, right? A lot of the things they did were completely cynical and manipulative, but, you know, you also can see situations where it would feel like speaking out, like truth to justice, like this is a thing that's happening and we need to like call it what it is, right? So.
And this is why my gut instinct is it would come down to subjective intent. If your intent is we need to pollute the jury pool so that we'll have fewer convictions, I think that's wrong. I think it's unethical. But the difficult question is that really a question of proof? I don't know. It's easy to pass a law and say, you're not allowed to do this with this specific subjective intent, but it's another to get into it from an ethical standpoint. And I think that one of the reasons why I was drawing upon 3.5 is there is that opinion that basically says it's not unethical to tell jurors about things that they weren't able to hear. It's unethical to intend to frustrate or change their future jury service. So there's precedent for the idea that it comes down to what is the subjective intent of the attorney. And I think that subjective intent to pollute the jury pool, and this is why I came up with, well, that's just straightforward application of 3.6. You shouldn't do things that are specifically intended to pollute the jury pool against your opponent. That's my feeling, at least.
So Hunter, are you saying that because it comes down to subjective intent, and that if your intent really is to pollute the juror pool, that it is inconsistent with 3.6, that this is not worth pursuing, or do you feel that this is worth looking at further?
I think it is worth looking at, but I'm not convinced that an opinion should issue, because, and kind of looking at our earlier discussion of the potential opinion on immigration, is this a straightforward application of just, you're not allowed to do this patently unethical thing? Is it that simple? When it comes down to, well, if your intent is to do something that's patently unethical, then you just can't do it. Does that require an opinion, or am I mistaking that? Is that not necessarily patently unethical? So I'm not convinced there needs to be an opinion, but I would really like input from the committee on whether they think an opinion might be worth looking into.
Well, my 2 cents is that you've already put a good amount of thought into this, clearly, and you've come up with interesting scenarios that have made us think about these issues. And if I'm hearing you right, this isn't quite ready to field yet, and that it merits at least a further look. And so my proposal to you, subject to what other people think, would be to flesh it out a little bit more, think through the scenarios a little bit more. You've already reached the conclusion in this issue outline about use of 3.6 instead of 3.5, and play with the scenarios and the particular ethics issues that you would want to address and how. And let's see what that expanded outline looks like. And then at that point in December, when we talk about that expanded outline, if you've now fully convinced yourself, this really isn't right for an ethics opinion, all right, then we can say let's hit the pause button. But if you think about it further and say, here's the trajectory that I see this going in an opinion, and I think that we should pursue it, great, we can have that conversation as well. So that would be my proposal, subject to what you think in particular, and then anyone else.
Well, if that's your view, Justin, then I'm more than happy to do more work. And like you said, flesh it out, give it the background of what the other side looks like, look into those scenarios more, and maybe draw upon some more ethical opinions about it. So I'm willing to do that, but welcome any feedback.
All right, well, hearing nothing, let's go with that approach. And if you want to talk about it between now and our December meeting, I'm around. Happy to connect with you and discuss. So thank you for giving us an update, Hunter, on and putting this together for us to look at. Appreciate it. So we're actually pretty much back on track in terms of time, so that's good. And for the new members, you'll be pleased to know that we always end with a hard stop at 4:30. We don't go over. So we all respect and guard our Fridays. The next and last topic for today is the lawyer as expert witness outline or opinion, I should say, which we have discussed on many occasions in this committee over the last year. And I think Sarah, you took the lead on the last edits here. So can I turn this over to you to give us an update on where we are?
Sure. And so this draft represents the red line since our last meeting. And just as a kind of general description, this ethics opinion is describing a lawyer serving as a testifying expert witness and the potential application of the rules of professional conduct to that lawyer's service as a testifying expert when he or she may be first to a client of the lawyer's law firm, either a former or client. We have different factual scenarios in the draft opinion. And this was significantly revised at our last meeting, thanks to one of our former members, Steve Bundy, who was our former advisor. And so I'll just go over some of the kind of key changes that I made based on the comments at our last meeting. This hasn't gone out for public comment yet. So the first change was on lines 49 to 51. And this was in response to Dina's comment at our last meeting. She wanted, and this is also addressed below, but she wanted to address when we're talking about imputation and the personal conflict of interests, add some more facts to show that there wouldn't be imputation under our factual scenario because there wouldn't be a significant risk of material limitation conflict. So I added a line here to make it clear that the expert was performing, and I guess I shouldn't have said his because we don't use his or her in our opinion. So I guess we should say expert performs expert services, maybe just delete the his independently, and no other lawyers at expert's law firm assist expert with such services or obtain access to plaintiff's confidential information. And I realize as I'm looking at this, these two sentences that are in red line should be reversed. So expert is engaged by plaintiff's lawyer should come first.
Sorry, which one do you want to go first? This one?
Just put that.
Got it. Okay.
Yeah. Thanks, Mimi.
No problem.
And so that was the first change. So I'll just stop since this was Dina's comment, and I know you made it below as well, Dina. So if you have any suggestions, or are you okay with that edit?
Yeah, I think that's great. That was my concern, just sort of like we talked about, that the confidential information that expert might have, that it could be imputed if other people were helping him in the law firm. And I think this is a good way to address that, which is to make clear that that's not going to happen here.
Okay. And so the next edit I made, and I don't think this next edit, I'm not happy with the way I made it. And I really welcome feedback. I really, every time I read this opinion, and I wasn't initially the lead drafter, but I have a difficult time distinguishing, and it might just be me, that the distinction between scenarios 3 and scenarios 4. And a lot of times I have to keep on going back to the scenarios in the beginning when we're getting to the application. So I was trying to come up with more clear parentheticals that clarify the difference between scenarios 3 and 4. So if you start on lines, it's really around line 62 to 75, where we're describing both of those scenarios. And I tried to sum up the scenarios in a parenthetical, because we're trying to put parentheticals, just short ones. So that way, when we describe them below, it's kind of clear what situation we're referring to. And I don't know if anyone's really had a chance to review this or focus on it, but I do welcome feedback on the descriptions and the parentheticals. I think maybe they could be more concise or even clarify the difference better than I have done so here. So has anyone had a chance to consider that issue? And maybe I'll just wait. I mean, if you could scroll down a little bit, if everyone's had a chance to review scenario 3 and then the different scenario 4, unless we're moving too quickly. So I don't know that we need to get into the details now, but I just welcome feedback on just the descriptions for scenarios 3 and 4. If you think there's a better way to describe those scenarios in the short parentheticals. Before it just said, I guess, concurrent expert and lawyer part 1 and then part 2. And I just thought that wasn't as helpful, because I kept on having to refer above when I was reading the rest of the opinion. So that is to these lines is really, I just intended to try to make it clearer, the distinctions. And then we can go on to lines 97 to 110. And this was, we had a discussion at our last meeting about whether we should keep in this extensive analysis on the issue of whether the testifying expert, whether the expert services would be considered the practice of law. And because we're not opining on the practice of law as a general matter for COPRAC, I thought it made sense to, and we already say that we're assuming for the purposes of our opinion that it is not the practice of law. I thought we shouldn't really get into this detailed analysis. So that's why I just really, there was a lot of analysis. We're making this assumption, but then we had this analysis of why the assumption is reasonable, which I really think then we are opining on whether it is the practice of law. So I propose deleting that that analysis, which falls on lines 97 through 111. And we had a discussion at the last meeting about this. And I know Adam, who was the lead drafter of this opinion, who just went off the committee. I know he was also in favor of removing this analysis, but I'll see if others have a strong opinion on this or want to weigh in. All right, so the next edit that I had is similar to the edit I just made, which is we also were addressing whether the expert services were considered law related for purposes of the application of the rules of professional conduct. And we had a pretty extensive analysis in this, starting on 111 and going on to the next page about whether or not it was law related. And then we ultimately conclude that in this situation, because the expert had a disclaimer in the engagement agreement and acted in accordance with the disclaimer, that the expert was not forming an attorney-client relationship, was not providing legal advice to the client, was solely acting as an expert because of that disclaimer, and because the expert acted in accordance with the disclaimer, that it wouldn't be considered law related. And so that's the conclusion ultimately reached. So I just tried to delete and shorten a lot of the analysis. If you go down a little bit, if you could maybe just to maybe the next page, you can see that.
Sorry, one second. What do you need me to move to?
Oh, if you could just scroll down to the next page, I was just showing how I deleted a lot of the analysis here on whether it was law related. Because we were really, again, kind of assuming it was based on the facts of our case. And so I didn't think we needed that extensive analysis. I kept some of it in there, and I did keep a reference to the ABA opinion, I believe in a footnote, but generally just tried to shorten the analysis. And then the other discussion we had at our last meeting was just where to put our discussion of the American Airlines case. Because we are distinguishing the American Airlines case in this ethics opinion. And before, the discussion fell under one of the scenarios, the application, and Steve Bundy made the recommendation to put it up front. He thought it was helpful. And after reviewing it again, I agree with that recommendation. So I just kept it where it was. I added a little bit of, I revised, but these edits I made to this section aren't really substantive. So I don't think we need to go over those as much. And then the final edits that I made are on lines 302 to 304. Yeah, and again, you'll see highlighted from our last meeting, Dina's comment, and this edit was similar to the edit I made up above and kind of the summary of the scenario, just to make clear that in this situation, there wouldn't be an imputation of the personal interest conflict of interest. And as I was reviewing this, which is scenario 2, I noticed in our prior discussion of scenario 1, we talk about, even though we're ultimately concluding that under scenario 2, that it wouldn't result in a violation of the rules in this particular situation where it's testifying expert and then a lawyer. I still think we might want to refer to there's still a risk of disqualification. As we stated in scenario 1, we have some language, and I think the shadow traffic case is somewhat on point for that. So I think it would be helpful just to make that note that for the reader, the risk of disqualification, similar to what we did for scenario 1. So that really, I kind of went over all of the key edits that I made since our last meeting. The other edits I made were not really substantive. They were more trying to clarify some of the factual information and just make the opinion a little more concise in certain areas. But I will open it up now for kind of general feedback, or if anyone has a response to that final question that I posed about whether we should mention the risk of disqualification here.
Thank you, Sarah, for that explanation of the changes. Does anyone want to chime in about Sarah's questions and these revisions? All right, well, why don't I start us off? So in terms of your last question about whether to refer to the risk of disqualification in scenario 2, I think that makes sense, whether it's a footnote or just a parallel comment to what's in scenario 1. If the risk is equally applicable in that scenario as scenario 1, I think we should say it. But on that same page, on page 10, where footnote 9, just a minor matter, I think we need to remove the phrase "and testifies," because I think the trigger is when the experts designated the attorney-client privilege is lost, based on my reading of those cases. So assuming you reach the same conclusion, I think we need to remove the "and testifies." Minor matter.
I actually don't know if I agree with that interpretation, but maybe highlight that if you could, and I can double check the cases.
Yeah,
because I thought
I've read them. Go ahead.
Yeah, and maybe, I don't know if these are the right cases, but my understanding was once they're designated, if they don't testify, you can kind of withdraw the designation and the privilege wouldn't be lost. But I could be mistaken. My memory might be off, but.
I thought that as well.
That's true.
And then I read these cases and they were ambiguous. And so I wonder if there's a better case than what we're citing to clearly enunciate the rule, because one of the cases, I can't remember if it's the Luca or the other, sort of cribs from another case and quotes it, and then by cribbing, and then it makes it another statement, which then leads to this conclusion that it's designation. And so you may absolutely be right, but how the I think the Luca case is framed, it makes it sound like it's designation that's the trigger. So maybe we got to think about what we cite here for the right proposition, which might be as it's stated.
And I just wanted to ask, Justin, if you could just, I look like maybe, do you go by William or Bill?
Bill.
Bill, did you have a comment on that point? It sounded like you were about to say something.
No, I don't think that the designation in and of itself is the determining factor. It's like the Shooker case. It's when the expert starts to testify. That's in that particular case, the expert was, I want to say it was retained counsel who had the actual, maybe it might have been former counsel, but anyways, there was an attorney-client relationship. It was only when the expert started to testify and get into and answer questions that would implicate the privilege that it was lost. But prior to that, even up to the date of the deposition, you can withdraw that expert. That's the way I read those cases. So I don't think it's as ambiguous as it sounds. I think it's once they testify or start to testify, then it's lost. Anytime before that, you're not disclosing any communication that would otherwise be privileged.
Yeah, and I for some reason I think that's right, because I thought that we initially had it the other way, and I changed it. I'm the one who added and testifies, and I don't know, for some reason I'm not seeing, I thought I had a comment on that, but I'll go back just to double check that, Justin, to make sure. But that's my call as well.
Let me know what you find, because this has always piqued my civil procedure curiosity. So
Sure.
I'd like to have it right in my own mind. What else? The scenario 3 and 4 and distinguishing them, it gives me a migraine trying to do that as well, Sarah. So I draw a diagram every time I read this opinion, trying to conceptualize the difference between 3 and 4. I have a few thoughts that I'll offer offline because it's going to be too hard to articulate in writing, but I do have some thoughts on how we can provide some of the language in scenario 4, because I think what the main difference is that the company that is the law firm's client is also a participant in scenario 3, where the lawyer is an expert, but in scenario 4, that the company who's the law firm's client has no relationship to the case. So, and it's really hard to articulate that in a clear way, and I think that's been one of the challenges. So I share your frustration. And by the way, Sarah has the best backgrounds on the committee. I don't know if you can see how organized and nice that background is. And I'm always jealous of those. They look like places you would want to work or live. So kudos to Sarah for always having the best backgrounds. And then I think one other comment I had when we cut the section starting at what was line 11.
Sorry, on what, where are we?
111.
111, okay. Let me just move this to the next page.
Yeah. So there, when we yeah, just up one to the bottom of the next page.
Oh, I just moved it down so it was all together.
So where it now says is generally considered law related for purposes of the application of the rules. Once we cut the next portion out, there isn't a cite to our conclusion. Is there something in these opinions or cases that we've now cut, that is there one that we would want to cite for this conclusion that we've reached, that or is it just we say we're not addressing whether a lawyer's service as a testifying expert witness, although a non-legal service is generally considered law-related. So for this proposition that generally considered law-related for purposes of application of the rules, do we need or want to cite something that we've cut here for that proposition, or do you not feel strongly about it?
Well, no, I want to see what follows, but I do think maybe just because we're associations for using the term law related, we probably want to add a cite just to explain what we mean by that. And if you could just maybe scroll down a little bit, I forget what follows here. Okay, let me say here, lawyer expert, sorry, expressly disclaimed writing.
I mean, I think the challenge is, of course, that it implicates Rule 5.7, which we don't have, which is why there was a lot of explication of California law, basically trying to suggest that we would analyze it similarly under Rule 5.7. And I think that's the problem. I mean, I think we want to think a little bit more about how we want to transition from this issue. I wasn't comfortable with the way it was left too, with cutting all this stuff out, because of course I was in favor of leaving some of this in. Not the first part, but the part about law-related stuff, or in a shortened, truncated way. But I do think if we're going to sort of even invoke the concept of a law-related business, I think we would want to suggest in text or in a footnote, some type of reference to those obligations to make that clear. I mean, we say the facts that this person, that the expert does, but I think we want to try to cite to, I guess the ABA opinion, but some of the California law that we interpreted to support the ABA's conclusions, even though we don't have 5.7.
If I could jump in, I do think that that's a challenge, and I don't know if the reference is necessary. I think this is a conglomeration of a different opinion that was trying to be resurrected for a point that might not be needed to be addressed in this opinion. So I totally agree that dropping the unauthorized practice of law piece is not only appropriate, but was necessary. And then similar, we don't have a Rule 5.7. And the times it's been considered in California, it has not been adopted. And there is case law, which says, such as Butler versus State Bar and other similar cases, where when you disclaim that you're not acting as a lawyer, you can relieve the client of any reasonable belief that you are their lawyer. And I would recommend just relying on what the law is in California for whatever proposition we're addressing here would be more prudent than trying to refer to a similar or analogous rule in other jurisdictions that we don't have here for this point. I think it creates more problems than we're anticipating.
Sorry, I tend to agree with what you were saying, Andrew. I just wanted to point out though, if you scroll down, Mimi, just the next page, I did include some sites here and a footnote 7 to add some of the authorities. If you could scroll down, I forget what I put in footnote 7, but I think I referenced that ABA opinion that discusses it. And another ethics opinion. I wanted to add another site here, but I didn't get a chance to. So I tried to incorporate some of the stuff just in a footnote, even though we're not opining on it, just for reference. And I did cite to some of the ethics opinions for our particular situation where we're including a disclaimer. So it wouldn't be reasonable for the consumer to believe that the expert was forming an attorney-client relationship.
Yeah.
So I thought this was a better way to handle it since we aren't really opining on that issue.
Well, if we're not going to sort of go there with that, then I think we need to take out the reference to sort of law related, period, right? That it's
right.
And go to the Butler cases and describe basically some of the case law in there that describes what California would require, which is what that was trying to marry those concepts because people are familiar with 5.7, but know that it doesn't exist in California, right? So, but if we're gonna not go there with that, then perhaps we shouldn't refer to it as like a question of whether it's law related, but just describe those cases about the disclaimer and satisfying an obligation that way. I don't know.
Because, I mean, I believe several of you do on the committee serve as expert witnesses or advised others who do. I assume you do say, I'm not your lawyer. You have a lawyer. I'm being retained, to provide whatever expert services you're being retained to provide. And it's not a reliance on 5.7 for that proposition. There are other bases for which you're establishing this, we want to call it a disclaiming of the attachment of the rules of professional conduct. And that's more of a question. I don't know that. That's just my sense of how California expert lawyers currently proceed, but I could be wrong. And if that's true, then I wouldn't want to muddle it with this law-related analysis.
Maybe, Mimi, would you please maybe highlight that? I guess it's the first sentence where we're using the term law related.
I think it's at the top of this page now, Mimi, where you did the heartbreak. Oh no, maybe it's the page above.
Yeah, it's
we
right
jumped
above.
down to footnote 7, so it's up here in this red. Go up above where the red starts. Yeah, right around there, I think.
I can work on this to try to remove this.
Because
but I don't want to remove it altogether now, just because I don't know if the paragraph will flow correctly. But I can.
Law related in quotes, that was the attempt to Californiaize ABA Model Rule 5.7. I don't even know if, because there are draft versions of a Rule 5.7, how that might look in California that have been developed by prior rules revision commissions. No, I stand corrected. The ABA rule is law related. Maybe it's, anyway, there's a.
I think it's ancillary business services is California.
There's a term, and I'm forgetting it, in the draft rule 5.7 that the California Rules Revision Commission has drafted. And it's not that they don't use the term law related. They use a different term. But now that I'm
Did you
thinking,
say, Cassidy, that it was?
I thought, I don't know what the rule revision says, but I thought in the ethics opinions that deal with dual professions, it's ancillary business services is what I recall from California, but I could be wrong.
I think that's right, Cassidy. And I think some of the opinions that are crossed out here, use that term, yeah.
Yeah, I think I would agree and be in favor of taking out, I think what we're saying, the quote in law related here. I mean, I think we could put maybe combine some of the footnotes, Sarah, about law related and a footnote or something and say, reference that ABA opinion and they've looked at it under this different standard about whether it's law related and we don't have that in California, but it seems like a similar outcome, right? But yeah.
That makes sense. So it looks like we only
we have 2 more.
Oh, so go on.
No, I was going to say we have 2 more minutes. So does anybody have any final comments or questions on this opinion? At least we were able to make some headway today on it, so that's good. All right. Well, I see we have 1 minute left. I just want to thank everyone for hanging in there until 4:30. We got through the technical hiccups, and I think we'll have smooth sailing for the rest of the year, come Zoom or in person. And again, we very much welcome all the new members. We're excited to have you here. Glad that you all are now engaged in some of our work for the committee right here on the first day. That's wonderful. If you have any questions, please feel free to reach out to me, Dina, Sarah, Andrew, Mimi. We're all here and want to answer all your questions and get you as engaged as we can. And thank you all. I hope you all have a wonderful weekend.
Thanks, everybody.
Have a great weekend.
Thank you.
Thank you. Bye-bye.
Thank you.